First schedule. Order 1. Party to suit. Rule 1 to 13. Which provision of the Code of Civil Procedure provide that one person may sue or defend on behalf of all in same interest? Order 1, Rule 8. Representation of suit under Order 1, Rule 8 of the CPC may be permitted by the court when numerous persons have same interest in one suit. A suit filed in representative capacity can be withdrawn, compromised, and abandoned, etc., by the plaintiff after notice to all the persons interested. Which one of the following is not required in filing the representative suit under Order 1, Rule 8 of the CPC? Written permission for those who are being represented. A suit under civil procedure can be filed in the representative character under Order 1, Rule 8. On account of misjoinder, non-joinder of party, under Order 1, Rule 9 of CPC, the suit cannot be dismissed. A suit may be defeated due to non-joinder of the necessary party. A suit in the representative capacity can be filed by the virtue of Order 1, Rule 8 of the CPC. Under CPC, where a person who is necessary party to the suit has not been joined as to the party, it is a cause of non-joinder. Under which provision of the Code of Civil Procedure the party can be struck out, added, and substituted? Order 1, Rule 10. Objection as to the non-joinder and misjoinder of the party under Order 1, 13 of the CPC should be taken at the earliest possible opportunity or shall be invalid. Which one of the following, which is the case of which notice to all the persons interested in the representative suit need not to be given? Addition of the new defendant in the suit. Necessary party is one in whose absence no order can be made effectively. Order 2. Framing of suit. Rule 1 to 7. As per Order 2, Rule 1 of CPC, every suit shall, as far as practicable, be framed as to afford the ground of final decision to prevent the further litigation. Order 2, Rule 2 of CPC does not apply to application for execution or writ petition. A let a house to B at a yearly rent of rupees of 500. The rent for the whole year whole of the year is 1905, 1906, 1907 is due or unpaid. A sue B in 1908 only for the rent due from 1906. A cannot afterwards sue B for rent due of 1905 and 1907. According to Order 2, Rule 3 of the CPC, a plaintiff may be united in same suit several days against the same defendant. Cause of actions. A let a house to B at a yearly rent of 10,000. The rent for the whole of the year of 2006 to 2008 is due unpaid. A sue B only in 2009 only for the rent due in for 2007. A cannot afterwards sue B for rent due in 2006 and 2008. A plaintiff can unite several causes of action in the same suit against the same defendant. Which provision of the code deal with the joinder of the causes of action? Order 2, Rule 3. Which one of the following is not a ground for the order to the court to the order separate trial under Order 2, Rule 6? None of the above. A plaintiff want to claim some relief in subsequent suit. He required leave under which one of the following provision of the Code of the Civil Procedure? Order 2, Rule 3. Order 3. Recognize agent and pleader. Rule 1 to 6. Several persons can be joined as a plaintiff in the case of where the right arises out of the same action in the favor of such person, where any common question of law is involved. Order 4. Institution of suit. Rule 1 and 2. Under CPC, every suit shall be instituted by the presentation of plaint in duplicate to the court or such officer as to appoint in this behalf. This is provided under Order 4, Rule 1. Under Order 4, Rule 1, Subrule 1, CPC, a suit instituted when a plaint in the duplicate is presented to the court. Under Order 4, Rule 1, Subrule 1, CPC, a suit is instituted when a plaint in duplicate is presented in the court. Order 5, Issue and Service of Summon. Rule 1 to 30. Under CPC, a copy of plaint shall be attached with the every summon. A defendant under Order 5, Rule 1 of CPC is required to appear the answer and claim to file a written statement within 30 days from the date of the service of summon. Thus, the summon for the service on the defendant can give in to the plaintiff under Order 5, Rule 9A of the CPC. Under Order 5, Rule 9, Subrule 3 of the CPC, the expenses for the service of the summon to the defendant has to be borne by the plaintiff. The court may also permit the service of summon by the plaintiff in addition to the service of summon by the court. Order 5, Rule 9A. Which one of the following statement is incorrect? Which one is correct? Where there are more defendants than one, service of the summons shall be made each of the defendant. Summon of the defendant cannot be served on his servant. Defendant may empower agent to receive summon. Where the defendant is absent at the time of service of summon, is sought to be effected on him, his residence. Where being no likelihood of his availability within the reasonable time and the absence of the empowered agent of the service may be made on any adult member of his family, any adult female member of his family. Where a defendant was avoiding service deliberately, the court ordered the service of the advertisement in a newspaper, but it did not order to affix the summon in the courthouse or the defendant's house also. The procedure adopted by the court is regular. Where a person's summon cannot be exercised, due diligence be found the summon may be served by affixing the same on the conspicuous place in the house. Where the defendant is confined in the prison, the summons shall be served to by delivery the summon to the officer in charge of the prison and service on the defendant. Order 5 of the CPC provide issue and service of summon. Where there are more than one defendant, the service of summon shall be made on None of the above. Rule as to issue of service of summon in the CPC laid down in Order 5, where the serving officer deliver or tender a copy of summon to the defendant personally or his agent, he must require such a person sign an acknowledgement of the service to endorse one of the original summon. Then the copy of summon will be delivered to the document. The original summon with defendant's signature thereon will be returned to the court. Where in the suit the defendant is absent from the resident, there is no likelihood of his being found at the residence within the reasonable time. The service of summon may be made on adult daughter. During the service of summon, the defendant was found absent from the residence and within reasonable time no chance to get back at his residence. The service of summon may be made on adult son. Order 7. Pleading generally. Rule 1 to 8. Pleading means plaint or written statement. Pleading has been defined in Order 6, Rule 1 of the CPC. Under the CPC, pleading means plaint or written statement. Pleading should state material fact. What is the essence of pleading? Plead fact, not law. In CPC, pleading does not include evidence. Pleading must state fact. No evidence is required to be pleaded in written statement, writ petition, counter affidavit. Which one of the following is not a rule of pleading? A state of law and pleading the fact. Pleading must be signed by the pleader and the party both. Pleading must be signed by the party and his pleader. Under Order 6, Rule 15 of the CPC, pleading must be verified by all the party if there are more than one or any one of the parties only. Under Order 6, Rule 16 of CPC, pleading on the ground that is scandalous, unnecessary, vexatious. The court may strike out any matter in any pleading which may be unnecessary, scandalous, frivolous, and vexatious, which may tend to prejudice, embarrass, and delay the fair trial of the suit, which is no abuse in the process of the court of law. Pleading can be altered, amended. Order 6, Rule 17. The court may at any stage of the pleading allow either party to alter or amend his pleading under which the following of the CPC. Order 6, Rule 17. Under which provision of the Code of Civil Procedure it is necessary for a party to prove that in spite of all due diligence the matter could not be raised before the commencement of the trial. Order 6, Rule 17. An amendment in the pleading shall effect from the date of the application. Under Order 6, Rule 17 of the Civil Procedure Code, the court can allow, alter and amend the proceeding to either party. An application for the amendment of the pleading is filed under Order 6, Rule 17. The court can allow the amendment in the pleading at any stage of the proceeding. Voluntary amendment is provided under Order 6, Rule 17. Amendment in the pleading shall not effective from the date of the application. Order 6 Rule 17 at any stage of the proceeding of the court can allow, alter and amend the pleading either party. Under Order 6 Rule 17 of the CPC, application for the amendment of the pleading can be allowed to either before and after the commencement of the trial. If party who has obtained any order for leave to amend the pleading does not amend the same within how many days, he shall not be permitted to without the leave of the court. 14 days. If no time is prescribed in order for carrying out the amendment, what is the period within which amendment is to be carried out under Order 6 Rule 18 of CPC? 14 days. If a party who has obtained in order to amend the pleading under CPC not amended after the expiry of how many days, shall not be permitted amend and same without the leave of the court. 14 days. Pleading means plaint and written statement. Which of the following fact must be stated in the pleading? Factum probanda.